Diane Hartwell arrived with 3 lawyers. The files were stacked 4 high on the plaintiff's table, the specific architecture of a case that has been built over months, organized and tabbed and cross-referenced, the kind of preparation that communicates to a room that the person doing the preparing believes they have the right to what they are asking for and intends to demonstrate that belief exhaustively. She had been preparing since before Leonard was in the ground. Miriam Cross arrived alone. Navy wool sweater, the canvas bag she had carried for 20 years, the one with the fraying handle that Leonard had offered to replace twice, and she had declined both times because the fraying was part of it now, part of how the bag had become hers. No briefcase, no folders, nothing that communicated preparation because Miriam Cross had spent 14 months being present at a hospital bedside and had not had time to prepare for this and was not going to pretend otherwise. Garrett Finch was already at the defense table. He had been Leonard's attorney for 11 years and had the specific quality of a man who carries things carefully, who understands that some documents are not legal instruments so much as they are a person's last words, and that last words deserve to arrive at the right moment rather than the convenient one. He placed a brown envelope on the table in front of Miriam's chair before she sat down. She looked at it. She did not open it. Leonard had told her in the last weeks that he had prepared something. He had said it the way he said important things briefly, directly, without elaboration. He had said, "Miriam, you don't need to know what I've prepared. You only need to know that I have." She had believed him. She still believed him. She sat down and put her canvas bag under the chair and folded her hands on the table and waited for the proceeding to begin. Diane's lead attorney stood for the opening argument and spoke for 22 minutes about undue influence and testamentary capacity and the particular vulnerability of a man in the final stages of cancer treatment who had changed his will 6 weeks before he died. He spoke about Leonard with the specific warmth of a man who had never met Leonard and was constructing a version of him that served the argument. He spoke about Miriam with the careful neutrality of someone who wanted to communicate suspicion without stating it directly. Miriam listened. She did not change her expression. Then Diane's attorney called Miriam to the stand. The room arranged itself into the specific attention of people watching something that is about to become definitive. Miriam stood. She walked to the stand. She sat. The attorney looked at his notes. Then he looked at her. He said, "Mrs. Cross, can you tell the court what you did for Leonard during his 14 months of cancer treatment?" The room was very still. Diane was watching her. The 3 lawyers were watching her. Judge Patricia Holm, who had been on the Mercer County probate bench for 19 years and had developed the economy of movement of a person who has stopped performing attentiveness because the attentiveness was simply always there, had her pen above her notepad. Miriam looked at the attorney. "She said I was there." 2 words, not delivered as an argument, not with the emphasis of a woman making a point. In the simple declarative register of someone describing a fact, the way you describe the weather, the way you describe the color of a wall, a thing that was true and required no defense because its truth was its defense. The pen in Judge Holmes' hand did not move. She did not look at the notepad. She looked at Miriam. Diane turned to her lead attorney. He was looking at his notes. He did not look back at her. In the front row of the gallery, Nora Taft closed her eyes. Not from sadness, from the recognition of something she had already heard the night before on the phone, when Miriam had said those same 2 words in response to Nora's question about what she was going to say if they asked her that. Nora had been quiet for a moment after hearing it. Then she had said, "That's enough, Miriam. That's the whole answer." She had known then. She knew now. The proceeding was not finished. There were documents and witnesses and arguments still to come. Leonard's sober accounting of 9 phone calls over 14 months. The handwritten addition he had placed at the end of his will that was not a legal clause, but a statement, the statement that Judge Holm would read aloud in a voice that changed register halfway through the first paragraph and did not change back. The chair on the porch at Harper's Ferry with its 2 letters carved under the seat waiting to be found. None of that had happened yet, but Nora Taft had her eyes closed in the front row of the gallery, and she was not afraid. And the reason she was not afraid was that she had heard Miriam Cross say 2 words the night before, and had understood that Leonard had chosen correctly. He had always chosen correctly. He had just made sure this time that the choice would hold. The doctor used the phrase 3 to 6 months on a Tuesday morning in March. He said it in the specific, careful language of oncologists who have learned that precision is a form of respect, not softening it, not extending it unnecessarily, just the plain fact of it delivered to the two people in the room who needed to hear it. Miriam was sitting in the chair beside Leonard's bed, where she had been sitting most mornings for 14 months. Leonard was propped against the pillows, looking at the window, rather than the doctor, which was how he received information he had already prepared himself for. He thanked the doctor. The doctor left. Leonard and Miriam sat in the room for a while without speaking, the way two people sit when the thing that needed to be said has been said by someone else, and there is nothing left to add to it. Miriam had her hand over his on the blanket. He was looking at the window. The March light was doing what March light does in West Virginia, still thin, still tentative, the light of a season that hasn't fully committed yet. At 11:15, the door opened. Diane Hartwell came in first. She was 49 and dressed with the careful correctness of a woman who had thought about what to wear to this visit, which told Miriam something even before the man behind her came through the door. He was in his 50s suit and briefcase, the particular efficiency of a professional accompanying someone to an appointment that has a purpose beyond the stated one. Miriam looked at Leonard. Leonard looked at Diane. He looked at her the way he looked at things he had been thinking about for a long time and had finally seen arrive, not with surprise, not with anger, with the specific settled quality of a man whose expectation has been confirmed. He turned to the doorway and spoke to the nurse in the hall. He said, "Please leave my wife in the room." Not a request, not aggressive, just a sentence that closed the question before the question was fully formed. Diane said, "Dad, I just want a few minutes, family things. There's no need for..." Leonard said, "Miriam stays." He said it the same way, flat without elaboration, with the economy of a man who understood that some sentences didn't need support because the support was in the sentence itself. Diane's attorney found a chair near the door. The visit lasted 22 minutes. Miriam watched it from the chair beside Leonard's bed, which was where she had been when Diane arrived, and where she remained not as a statement, not as a position, but simply because this was where she sat. She had been sitting in this chair for 14 months, and there was no reason, none that she could see, to sit somewhere else. Diane spoke about the house, about the estate, about Leonard's wishes or her understanding of them, which she presented as the same thing. She used the word family in the specific way people use it when they mean bloodline rather than the people who have been present. She looked at Miriam twice during the 22 minutes, not at her directly past her, the way you look past something you have decided isn't the subject of the conversation. Leonard listened. He said very little. When Diane stood to leave, she did not look at Miriam. The attorney followed her out. The door closed. Leonard turned to the window again. Miriam waited. He did not say anything about what had just happened. She did not ask. In 14 months, she had learned the specific language of his silences, which ones were exhaustion, which ones were pain, which ones were the particular quiet of a man processing something he intended to act on rather than discuss. This was the third kind. That evening, when the floor had gone quiet and the light had shifted to the particular yellow of hospital evenings, Leonard reached into the drawer of the bedside table. He took out a small notebook. Miriam had not known it was there. In 14 months of sitting beside this bed, of managing this drawer, of reaching past it for water and medication, and the television remote, she had not known the notebook existed. He had kept it in the back behind things in the specific way a person keeps something they intend to use at the right moment and not before. He opened it. He wrote something. He closed it and put it back. Miriam looked at him. He took her hand. He said, "Miriam, there are things I've done not to protect you, but so you won't need protection." She thought he was talking about the insurance policies, about the financial planning he had done in the first months after the diagnosis, the conversations with Garrett Finch she had not attended because Leonard said they were routine. She thought he was talking about forms and accounts and the ordinary legal preparation of a man who was taking his responsibilities seriously. She understood much later that he was talking about the notebook. 6 weeks after Diane's visit on a Wednesday afternoon in April, Leonard signed the revised will. Garrett Finch came to the house in Harper's Ferry with 2 witnesses, a neighbor from down the road, and a woman from Garrett's office whom neither Leonard nor Miriam had met before, which was the point. They sat at the kitchen table. Leonard read the document aloud in full, which Miriam did not know, until Garrett told her later was something Leonard had specifically requested, had said he wanted it on the record, that he had read every word, that there was no ambiguity about his comprehension of what he was signing. Miriam was upstairs. She did not know what was happening at the kitchen table. She came down 20 minutes after Garrett's car left the drive, and Leonard was in his chair by the window, the one that looked out over the 3 acres, the apple tree, the woodpile, the porch where the wooden chair sat. He said, "I'm tired, but today I slept well." She made him chamomile tea. She turned off the lamp. She sat beside him in the dark for a while, and then he was asleep and she went upstairs. She did not know that downstairs on the kitchen table where the signing had happened, Leonard had left one thing, not the will which Garrett had taken, but a single sheet of paper, in Leonard's handwriting, folded once with Garrett's name on the outside. She did not know about the notebook in the bedside drawer. She did not know about the chamomile tea being in some way she could not have articulated exactly what Leonard had been thinking about when he signed his name that afternoon. She only knew he had said he slept well. That had been enough. The weeding was something Miriam did when she didn't know what to do with her hands. It was not a conscious decision. She had simply found herself in the back garden 3 weeks after the funeral on her knees, in the dirt pulling the early spring weeds that had come up in the beds Leonard had built their second year in Harper's Ferry. He had built them from cedar boards measured and leveled with the specific care he brought to things he intended to last, and she had been planting them every spring since, and weeding them every week, and the weeds had come up as they always did, indifferent to everything. Her phone rang at 9:10. "Garrett Finch." She sat back on her heels and answered. "He said Diane filed this morning. Mercer County Probate Court." She stayed where she was for a moment on her knees in the garden, the phone against her ear, the early April light coming through the apple tree, the way it came in April, thin and provisional. She could hear Garrett turning pages on his end of the call. She said, "Tell me." 67 pages. Garrett read her the key sections over the phone, which he did because he had been Leonard's attorney for 11 years, and understood that the difference between reading and summarizing was the difference between a person receiving the actual thing and a person receiving someone's interpretation of the actual thing. He read the language as written. 2 primary claims. The first, undue influence. The filing alleged that Miriam Cross had systematically manipulated Leonard Cross during his cancer treatment, exploiting his diminished capacity. Diminished the filing specified by the opioid pain management protocol Leonard had been on for the final 7 months of his life, to induce him to revise his will in her favor. The filing described Miriam as having exercised complete control over Leonard's living environment during his most vulnerable period. The second, testamentary incapacity. The filing alleged that Leonard Cross, at the time he signed the revised will, 6 weeks before his death, did not possess the legal capacity required for a valid testamentary act. As evidence, the filing cited a physician's notation from Leonard's medical record confusion episodes documented in the final 3 months of treatment and Leonard's opioid prescription history. The third category of evidence was a list. 14 occasions dated and described on which Miriam Cross had allegedly prevented Diane Hartwell from accessing her father. Garrett read the section describing Miriam. "She had exercised complete control over the living environment of my father during the period in which he was most susceptible to influence depriving him of independent contact with his biological family and positioning herself as his sole conduit to the outside world." Miriam set the phone on the garden bed beside her. She looked at the apple tree, at the cedar beds, at the back of the house where she had lived for 16 years, where Leonard had built the porch, and then the chair, and then the woodpile, and then all the other things a man builds when he has decided a place is his and intends to make it so. She picked the phone back up. She said, "Garrett, I never stopped Diane from coming. Diane didn't come." He said, "I know." She said 14 times. She's listed 14 times I prevented her. He said, I know what the list says, Miriam. I also know what the notebook says. And I know what the addendum says. We have time before the hearing. We have what we need. She said, what notebook? A pause. Garrett said Leonard asked me to hold some things until the right moment. I'm going to ask you to trust that, the same way you trusted him. She was quiet. She said, all right. She said it the way she had said all right to Leonard for 16 years, not as surrender, not as the closing of a question, but as the specific 2 syllables of a person who has decided to extend their trust and is at peace with the extension. She stopped reading the filing at page 12. Not from avoidance. She had read page 12 and understood that pages 13 through 67 would be more of the same thing, the elaboration of a case that had been built over months and that she could not rebut by reading more of it. She folded the pages and put them in the kitchen drawer where she put things she needed to keep but did not need to see every day. That evening she called Nora. Nora Taft had been her closest friend for 20 years. The specific friendship of 2 women who had been through enough of life's serious weather together that they no longer needed to explain context. Who could begin a conversation at the exact place it needed to begin? Nora said, do you remember the last time Diane visited Leonard before he was admitted? Miriam was quiet for a long moment. She said, I remember the last time. It was his birthday the year before the diagnosis. She came for lunch and left before dinner. After that, she called sometimes. She stopped. She said he waited for her to call on his birthday. Last year, he was in the hospital. He waited from 9 in the morning. Nora said, did she call? Miriam said no. She looked at the window. The evening was coming down over the Harper's Ferry hills in the specific way of April evenings in West Virginia. The light going slowly, the sky above the ridge going through several versions of itself before settling into dark. She said, I bought a small cake from the hospital bakery, 1 candle. I sang to him. She said he smiled. But before he blew out the candle, he looked at his phone one more time. Nora was quiet. Miriam said he didn't say anything. He just looked. Later that evening, she went to the porch. She sat in the wooden chair Leonard had built the first year they moved to Harper's Ferry, the one he had spent 3 weeks on, which she had always thought was excessive for a porch chair, until she understood that Leonard did not build things quickly and did not build things carelessly, and that 3 weeks for a porch chair meant the chair would last 30 years and be exactly right. She put her hand on the back of it. She had been sitting in this chair for 16 years and had never looked at the underside. She had never had a reason to look. It was a chair. You sat in it. It held. She sat in it now and looked out over the 3 acres, the apple tree, the woodpile, the edge of the property where the old fence Leonard had replaced in 2019 marked the boundary, and thought about Leonard building this chair. 3 weeks? She had asked him once early on, why a chair? Why not the garden beds first? Why not the woodshed roof that needed attention? He had looked at her and said, because when you sit on a porch, you need to know the chair is right. Everything else can wait. She had thought he was talking about chairs. She sat on the porch in the April evening with her hand on the back of a chair a man had spent 3 weeks building, and she did not yet know what was carved under the seat, and she did not need to know yet. She just needed to sit, and the chair held. Garrett's office was on the 2nd floor of a building on Federal Street in Bluefield that had been there long enough to have developed the particular solidity of a place where serious things had happened for decades without requiring anyone to make a fuss about it. He had practiced law here for 30 years. The office had bookshelves that had been filled gradually and a desk that showed its use, and a window that looked out over the street with the calm indifference of a window that has seen many difficult conversations and expects to see more. He had called Miriam on a Thursday morning. He had said, I need you to come in, not to talk strategy. There's something Leonard left with me that you need to see. She came on Friday. He did not begin with the files on his desk or the legal analysis he had been preparing since Diane filed. He began with the safe. It was a standard office safe set into the wall behind the bookshelf, the kind that holds documents that need to be held carefully. He opened it with the combination and reached inside and placed 3 items on the desk between them. A notebook. Small, the kind sold in hardware stores, a laborer's notebook with the cardboard cover and the narrow ruled lines that are meant for notes taken in the field rather than at a desk. The cover was worn in the specific way of something carried in a pocket for a long time. A will. The revised document properly formatted, the notary's seal at the bottom of the last page. A brown envelope, letter-sized, unsealed. Miriam's name on the outside in Leonard's handwriting. Garrett placed his hand on the notebook first. He said, "Leonard gave me this 9 months before he died. He came in without an appointment, walked in on a Tuesday afternoon and sat down and put it on the desk and said, 'If Diane contests, the will show this to the court. If she doesn't, burn it.'" He said he didn't explain it further. He didn't need to. He slid the notebook across the desk. Miriam picked it up. The first page was dated the month Leonard's treatment began, 14 months before he died. His handwriting, the specific compressed print she had been reading for 16 years, the handwriting of a man who believed that legibility was a form of respect for whoever would need to read it. At the top of the page, a date, below it a notation. She turned the page. Another date. Another notation. She understood within the first 3 pages what she was looking at. Leonard had kept a record of every time Diane called during his treatment. Date, time, duration, 14 months, 9 entries. She read them slowly. The calls were brief. The average duration as she moved through the 9 entries was 4 minutes, some shorter. One on a Sunday in October had lasted 11 minutes, which was the longest. She checked the date and remembered that Sunday, Leonard had been in a difficult week, the nausea from the second round of chemotherapy worse than the first, and she had been in the kitchen making soup when his phone rang, and she had heard him answer, and then heard his voice take on the specific quality it took when he was conserving energy for a conversation that required more than he had available. 11 minutes. Beside each entry, Leonard had written a note, not in the tone of a man cataloging grievances. In the tone she recognized from 16 years of knowing him, the flat, observational tone of a man noting what he saw without deciding in advance what it meant. Beside the first call, asked about the insurance. Beside the third, asked about the house, what would happen to it. Beside the 5th, the Sunday call in October, did not ask about the pains. She read all 9. None of them said didn't come. None of them expressed what she could see, accumulating across the pages, the specific shape of 9 calls over 14 months, the pattern of what was asked and what was never asked, the arithmetic of a daughter's presence rendered in minutes and dates. He had not needed to write what he concluded. The record wrote it. She turned to the last page. One entry. The date she recognized as the day Diane had appeared at the hospital with her attorney, the day Leonard had said, "Please leave my wife in the room," the day of the 22-minute visit. The notation, "Diane came today. I was right." 4 words. No elaboration, no anger in the handwriting, no pressure in the pen. The same flat, observational quality as every other entry, a man noting the confirmation of something he had understood for a long time and was not surprised to see arrive. Miriam closed the notebook. She set it on the desk. She said quietly, not to Garrett exactly, more to the space the notebook had occupied in her hands. "He knew. He knew before I did." Garrett said he knew from the 2nd month, Miriam. He told me when he brought the notebook in. He said he had known since the 2nd call, had understood from the way Diane asked her questions what she was preparing for. He said he spent the next 12 months making sure that when the time came, she wouldn't succeed. He said he didn't tell you because he didn't want you carrying it. He said you had enough to carry. Miriam looked at the window. She thought about Leonard in the 2nd month of treatment, the months she thought she had known completely, the months she had been present for, sitting in the chair beside his bed, reading to him on the bad days, making the tea he liked on the good ones. She had thought she knew what those months were. She had not known about the notebook in the bedside drawer. She had not known about the Tuesday afternoon he had walked into this office and put the notebook on this desk and said, "If she contests, show this to the court." She had been in the chair beside his bed. He had been building something. Both things were true at the same time. Garrett reached for the brown envelope. He said, "There's one more thing." Leonard added a handwritten note to the will, Not a legal clause, just a statement. He wrote it the same afternoon he signed. He gave it to me separately and asked me to keep it with the will. He said I haven't read it aloud to anyone. Leonard asked me to save it for the courtroom. Miriam looked at the envelope. She did not take it. She said he said I didn't need to know what he'd prepared, just that he had. Garrett said, "Yes," she said, "then I'll wait." She drove home through the April hills in the specific quiet of a person who has received a large piece of information and is giving it the room it needs before she decides what to do with it. She thought about Leonard in the kitchen their first winter in Harper's Ferry, the evening she had fixed on, as the moment she understood who he was. He had been at the counter peeling apples. She had been at the sink. They had been in the kitchen together for 20 minutes without speaking, and neither of them had felt the need to fill it. And then Leonard had said, without looking up from the apple, "I like people who don't need to say everything out loud." She had said, "I'm like that too." It was the first time she had known with the specific certainty that arrives, rather than develops, that he loved her. She had been right. He had been building the proof of it for 14 months without telling her. That was who he was. That was who he had always been. The November sky over Bluefield was the particular gray of a day that has decided not to commit to weather, not raining, not clearing, simply present in the flat, overcast way of late autumn in the West Virginia hills when the color has gone from the trees, and what remains is the honest structure of things. Miriam arrived at 8:45. She wore the navy sweater, the canvas bag, nothing that communicated preparation because the preparation she had done was not the kind that showed in what you carried. Garrett was already at the defense table with his briefcase open and the brown envelope placed in front of Miriam's chair, where it had been since he set it there before she sat down. She looked at it when she sat. She had been looking at it in some peripheral way since Garrett had shown it to her in his office 3 weeks ago, had been aware of it as a thing that existed that Leonard had written that she had not read and would not read until the courtroom. She trusted Leonard. She had trusted him for 16 years. She was not going to stop on the last day it mattered. Diane's table had the particular organization of serious preparation. 4 stacks of folders, each tabbed and color-coded the legal architecture of a case built over months. 3 attorneys. Thomas Veck at the center, 55 years old, with the settled authority of a West Virginia litigator who had been in rooms like this one many times and had developed through that experience the specific confidence of a man who believed that preparation was a form of destiny, that if you build a case correctly, the outcome was not a question but a conclusion. He opened with 40 minutes. He was good at it. He spoke about Leonard with the warm specificity of a man who had done his research, knew the dates, knew the medical history, knew the opioid protocol, and the confusion episodes and the particular vulnerability of a man in the final months of terminal cancer. He built the picture carefully piece by piece, the way a good litigator builds things, not asserting conclusions, but laying evidence in sequence and allowing the conclusions to appear to arrive on their own. He spoke about Miriam with the careful neutrality that was its own form of accusation, noting her presence, her access, her role as the primary caregiver, the natural conduit between Leonard and the outside world, and allowing the jury. There was no jury. Only the judge, but Veck argued as though the gallery were 12 to draw the obvious inference. Judge Patricia Holm listened without expression. She had been on the Mercer County probate bench for 19 years and had heard many opening arguments and had learned through that experience to listen completely rather than reactively to receive the argument as the argument and wait to see what arrived after it. Garrett's opening was brief. He said Leonard Cross knew exactly what he was doing. He prepared for this proceeding with the same care he brought to everything he built. We have his preparation. When the court has seen it, we won't need to say anything further. He sat down. Veck called Miriam to the stand at 10:10. She walked to the stand the way she walked most places, without hurry, without the performance of composure, simply moving from one place to another with the economy of a person who is not thinking about being watched. She sat down. She folded her hands. Veck approached with a legal pad and the relaxed confidence of a man beginning a process he had rehearsed many times. He started with the small questions. When had she met Leonard? When had they begun seeing each other? When had they married? How long had they lived in the house in Harper's Ferry? The questions of a man establishing a timeline, building a foundation, making the record. She answered each one directly, without elaboration, in the specific economy of a person who gives the question what it requires and nothing more. He turned a page on his legal pad. He said, Mrs. Cross, in the 14 months of Leonard's cancer treatment, you served as his primary caregiver. Is that accurate? She said yes. He said you were present at the majority of his medical appointments. She said yes. He said you managed his daily schedule, his medications, his communications. Garrett said, objection. Compound. The judge said, sustained. One at a time, Mr. Veck. Veck nodded. He said you were present when Leonard communicated with family members, including his daughter Diane. Miriam said I was present when Diane visited. Diane visited once in 14 months. A small sound from Diane's table, not loud. Veck continued without acknowledging it. He said, Mrs. Cross, you had significant influence over who had access to Leonard during his treatment. Is that your testimony? Garrett said, objection. Mischaracterizes the evidence. The judge said, I'll allow it. The witness may answer. Miriam said I didn't control who had access to Leonard. Leonard decided who was in the room. I was in the room because Leonard asked me to be. Veck let that sit for a moment. He looked at his legal pad. He looked at Diane. Diane gave him a small nod, the nod of a person confirming that they have arrived at the prepared moment. He turned back to Miriam. He said, Mrs. Cross, can you tell the court what you did for Leonard during his 14 months of cancer treatment? The room went still, not the ordinary quiet of a proceeding between questions. The specific stillness of a room that is understood collectively and without announcement that the question just asked is the question the morning has been building toward, and that whatever comes next will determine the shape of everything that follows. Diane was watching her. The 3 attorneys were watching her. Nora Taft, in the front row of the gallery, had her hands folded in her lap and was watching her with the expression of a person who already knows the answer and is waiting for the room to hear it. Miriam looked at Thomas Veck, not at Diane, not at the judge, at Veck, at the man who had asked the question and was waiting for the answer he had prepared to dismantle. She said, I was there. 2 words, not delivered with emphasis, not as a closing argument or a performance or the rhetorical move of a woman who had prepared this answer and was now deploying it. In the plain declarative register of someone describing what happened the way you describe the weather, the way you describe the color of a wall, a fact stated in the simplest available language because the simplest available language was exactly sufficient. Veck's pen moved toward his legal pad. It stopped. He did not write anything. He looked at Miriam. She was looking back at him with the same steady attention she had been giving things for 68 years, the attention of a woman who did not perform her presence, because her presence did not require performance. Judge Patricia Holmes set her pen down. She did not look at her notepad. She looked at Miriam with the specific full attention of someone who has just heard something that has landed differently from everything that preceded it, not as evidence, not as testimony, but as a plain description of a thing that was true and had been true for 14 months in a hospital room while a man she loved was dying. Diane turned to Veck. Veck did not look at her. He was still looking at Miriam. He said after a moment, no further questions. He sat down. In the front row, Nora Taft closed her eyes, not from sadness, from the recognition of something completed the specific piece of a person who heard 2 words the night before on the phone and understood immediately that those 2 words were the whole answer and who had been right and who was now sitting in the front row of a West Virginia probate courtroom watching a room full of people arrive at the same understanding she had reached the night before in her kitchen. She had known. Leonard had known. The envelope on Garrett's table was still sealed. It was not yet time for it. But the room had already shifted, had moved in the space of 2 words from a room in which a case was being argued to a room in which the truth had entered and was simply waiting for the legal proceedings to catch up with it. Garrett did not cross-examine. He looked at the judge. He said, Your Honor, the defense would like to call 1 witness and submit 1 document. The judge said, Proceed. Vec recovered within seconds. He had been doing this for 30 years and had developed through that practice the specific resilience of a litigator who has encountered unexpected moments in courtrooms before and has learned that the worst thing you can do with an unexpected moment is let the room see you recalibrate. He turned back to Miriam with the expression of a man who has heard what he heard and has decided it does not change his approach. He said Mrs. Cross, with respect being present, is not a legal standard. The question before this court is whether Leonard Cross possessed the independent judgment to— Judge Holmes, said Mr. Vec. Her voice was not sharp. It was the voice of a judge who has decided something and is communicating the decision in the minimum words required. She said, I believe the witness answered the question. If you have further questions for this witness, please proceed. If not, Mr. Finch is waiting. Vec looked at his legal pad. He looked at Diane. He said no further questions at this time. He sat down. Garrett walked to the front of the courtroom the way he walked everywhere, without performance, with the economy of a man who understood that the most effective thing he could do in a room where something important was happening was to be entirely present in it and entirely undemonstrative about that presence. He was carrying the notebook. He held it in his left hand, not open, not displayed, simply carried the way you carry something you have been entrusted with and intend to deliver correctly. He said, Your Honor, I'd like to submit this notebook as evidence. It was provided to me by Leonard Cross 9 months before his death with specific instructions regarding its use. Diane's lead attorney was on his feet before Garrett finished the sentence. He said, Objection. The provenance of this document hasn't been established. There's no verification that this is Leonard Cross's handwriting. The document could have been— Garrett reached into his briefcase. He placed 3 additional documents on the clerk's desk, a letter Leonard had written to Garrett in 2019, formally typed and signed by hand, the deed to the Harper's Ferry property signed by Leonard at closing, and a handwritten note Leonard had sent Garrett the previous Christmas 2 months before the diagnosis. He said 3 documents, all bearing Leonard Cross's handwriting, all previously authenticated through notarization or official record. I'm asking the court to compare. Judge Holmes looked at the documents. She looked at the notebook. She put on her reading glasses and held the notebook open beside the 2019 letter. The room was quiet. She said the handwriting is consistent. Objection overruled. The notebook is admitted. Garrett opened it. He did not read the full contents. He had thought carefully about what to read and what to leave, in the way a careful person thinks about what to say and what to allow silence to carry. He had decided on 3 entries. He said, I'm going to read 3 entries from this notebook into the record. Leonard Cross's words in his own hand, dated over the 14 months of his cancer treatment. He turned to the first entry. He read Diane called. 4 minutes, asked about the life insurance policy. He turned several pages. He read Diane called. 3 minutes, asked about the house in Harper's Ferry. Did not ask about the pain. He paused. The room absorbed those 7 words, the way rooms absorb things that have been said plainly, not with drama, not with the emphasis of argument, but with the flat specific weight of an observation made by a man who was noting what he saw. Did not ask about the pain. Garrett turned to the last entry. He read, Diane came today, I was right. He closed the notebook. He set it on the clerk's table. The room was quiet in the specific way of rooms in which something has been said that cannot be unsaid, not because it was loud, but because it was true, and because its truth was of the kind that once heard reorganized the listener's understanding of everything that preceded it. Garrett returned to the defense table. He reached into his briefcase. He produced a medical document, a formal assessment report on the letterhead of a neurological practice in Charleston, dated 8 weeks before Leonard had signed the revised will. He said Leonard Cross requested a neuropsychological evaluation 8 weeks before he signed the revised will. He requested it independently without informing any family member, including Miriam. He chose a specialist with no prior connection to his treatment team. He submitted the document to the clerk. He said the evaluating physician's summary states, and I'm quoting directly, patient demonstrates clear awareness of the nature and extent of his assets, clear identification of the intended beneficiaries of his estate, and clear comprehension of the legal and practical consequences of his testamentary decisions. Patient's decision-making capacity is fully intact. He said Leonard Cross was not confused. He was not managed. He was not manipulated. He was a man who understood exactly what was happening to him and who took specific, deliberate, independent steps to ensure that his intentions would be honored after he was gone. He paused. He looked at the judge. He said, "Your Honor, Leonard Cross also left a handwritten statement, not a legal clause, not a codicil. He called it his reasons. He wrote it on the afternoon he signed the will after the witnesses had left, and before Miriam came downstairs. He asked me to keep it sealed until the courtroom required it." He picked up the brown envelope. He held it for a moment. Miriam was looking at it from the defense table. She had been looking at it since Garrett placed it there before the session began, had been aware of its existence since Garrett showed it to her 3 weeks ago in his office, sealed with her name on the outside in Leonard's handwriting. She had not asked him to open it. She had not opened it herself. She had trusted Leonard. She was still trusting him. Garrett walked to the clerk's desk and placed the envelope in front of Judge Holm. He said, "The defense submits this statement and requests that Your Honor read it into the record." Diane's attorney stood. He said, "Objection, Your Honor. A handwritten personal statement is not." The judge said the court will determine admissibility, Mr. Veck. She picked up the envelope. She looked at the outside Miriam's name in Leonard's handwriting and below it in the same hand for the court if needed. "I hope it is needed." She opened it. She removed a single page, Leonard's handwriting, the same compressed, deliberate print from the notebook, the handwriting of a man who believed legibility was a form of respect. The page was full but not crowded, the lines straight, the margins even. Not a single word had been crossed out. He had written it once? He had been certain. Judge Holm put on her reading glasses. She began to read. Garrett opened the envelope. He did it at the clerk's desk, standing with the specific, unhurried quality he brought to everything that mattered. Not slowly for effect, not quickly to get it done, but at the pace of a man who understands that some documents deserve to be handled, the way you handle something that has been waiting a long time to arrive at the right place. He removed a single page. He unfolded it. He looked at it for a moment, not reading he had read it before, but receiving it again the way you receive something you have been holding carefully and are now about to release. He said, "Your Honor, with the court's permission, I'll read this into the record." The judge said, "Proceed." Garrett read. He read it in the voice he used for things that required no amplification level, clear without the rhetorical shaping that would have made it a performance rather than a delivery. Leonard's words in Leonard's order, exactly as written. He said, "I am writing this because I want the record to contain my reasons in my own words, not in legal language, not through an attorney, but as I would say them if I were in the room. I leave everything to Miriam not because Diane is undeserving as my daughter, but because in the 14 months I spent learning how to die, Miriam was the only one there learning it with me. Diane came when I was nearly finished. Miriam was there from the beginning. I am choosing the person who stayed." He folded the page. He placed it on the clerk's desk. He returned to the defense table and sat down. The room was still, not the ordinary quiet of a proceeding between moments, the specific complete stillness of a room in which something has entered that is larger than the proceeding, the stillness that comes when a person who is gone has spoken in their own voice, in their own words, and the room has understood that the voice is the voice of someone who knew exactly what they were saying and had thought about it for a long time before they wrote it down. Judge Patricia Holm was not writing. She was looking at the page on the clerk's desk. Then she looked at Miriam. Miriam was sitting at the defense table with her hands folded and her canvas bag under the chair, the way she had been sitting since the session began. She had heard the words. She had heard them the way you hear something that confirms what you knew, without knowing you knew it not as revelation, but as recognition, the specific feeling of a truth arriving in the form it was always going to take. Her eyes were wet, not from grief, not the grief of loss which she had been carrying for months and had learned to carry. from the specific, complete feeling of being known, of having been watched by someone who saw clearly and had written down what he saw in the plainest language available to him, and had entrusted it to a courtroom in West Virginia so that the record would contain it permanently. Leonard had watched her for 14 months. He had seen what he saw. He had found the right words. Diane was looking straight ahead, not at Garrett, not at Miriam, not at the judge. At the middle distance, the specific focal point of a person who is processing something they cannot fully process in public and has chosen the only available option, which is to hold themselves very still and look at nothing. She was not crying. She was doing something harder than crying. She was sitting with the specific weight of a sentence that had named the shape of something she had already known in some part of herself and had not wanted to name. Diane came when I was nearly finished. Miriam was there from the beginning. She could not argue with the sentence. She could not redirect it or reframe it or submit a counter-argument that would change what it said. It said what it said. It said it in her father's voice, in her father's handwriting, with her father's precision. In the front row of the gallery, Nora Taft had her eyes closed. She had heard Miriam describe those 14 months over 20 years of friendship, the nights without sleep, the mornings making thin broth when Leonard couldn't manage anything solid, the changing of sheets at 3 a.m, the specific exhaustion of a person who is present for someone else's dying with the full weight of their presence. She had known all of it. She was not surprised that Leonard had written what he wrote. She was surprised quietly, completely, that he had found exactly those words, that he had managed to say in one sentence the thing that took 14 months to live, and that most people would not have been able to compress into any number of sentences. Miriam was there from the beginning. I am choosing the person who stayed. He had known what he was writing. He had always known. Judge Holmes set the page flat on the bench in front of her. She looked at Diane for a long moment, not with judgment, not with the expression of a jurist who has reached a conclusion and is communicating it through her gaze, with the plain, steady regard of a person who has just heard something true and is looking at the person for whom the truth was most difficult to hear. Diane did not look back. At the plaintiff's table, Thomas Veck leaned toward his client. He said very quietly, "We should consider." Diane said no. One word, flat without inflection, the word of a woman who has heard what she has heard and has understood what it means and is not going to discuss alternatives. Veck sat back. Judge Holmes said the court will recess for 15 minutes. She stood. She walked out. The room was quiet for 2 full minutes after the door closed behind her. No one spoke. Not Veck, not Diane's other attorneys, not Garrett, not Miriam, not the gallery. The page Leonard had written was on the clerk's desk, entered into the permanent record of Mercer County Probate Court, his words in his hand in the room where they had needed to be exactly as he had intended. He had said, "I hope it is needed." It had been needed. He had prepared it anyway. The coffee shop was 2 blocks from the courthouse. Garrett had been going there after difficult proceedings for 20 years, not because it was particularly good coffee, though it was decent, but because it was close and quiet and had booths in the back where you could sit without the particular exposure of a window table. He had chosen the back booth. He ordered without asking the way he had been ordering for Miriam since the first week after Leonard died, when he had realized she was the kind of person who would not ask for what she needed and had decided that asking on her behalf was part of his job. 3 coffees. Something warm and sweet that neither of them would necessarily eat, but that the hands could hold. They sat for a while without speaking. The official ruling would come the following week. The formal written decision of Judge Patricia Holm entered into the permanent record of Mercer County Probate Court. But the 3 people in this booth had been in the room when Leonard's words were read and had felt the specific quality of air that enters a room when a truth has been stated that everyone present understands cannot be undone. They knew. Garrett wrapped his hands around his cup. Then he reached into his briefcase. He placed a small key on the table between them. It was a simple key, the kind used for a padlock, small enough to sit in the center of Garrett's palm, worn at the bow in the way of something that had been in a drawer for a long time. He said, "Leonard left this with me. He said you would know what it opens when you were ready. He said not to give it to you before the proceeding was finished. Miriam looked at the key. She picked it up. She knew immediately. There was a wooden box in the garage, a small one-seater that Leonard had kept on the shelf above the workbench for as long as she had been in the house. It had a padlock she had never seen opened. She had noticed it in the early years and had asked once casually what was in it. Leonard had said tools for a project. She had not asked again because Leonard had projects that were his, in the way that some things are a person's, without requiring explanation, and she had understood that and respected it. That had been 5 years ago. She had not thought about the box since. She drove home alone. Nora said she would come by in an hour. The garage was the way Leonard had kept it organized, with the specific precision of a man who believed that knowing where things were was a form of respect for the work they enabled. The box was on the shelf above the workbench, exactly where it had always been the small padlock in the hasp. She put the key in. It turned. She lifted the lid. Inside folded once a piece of paper, not a legal document drafting paper, the kind with the faint grid lines that engineers and carpenters used, slightly yellowed at the edges in the way of paper that has been stored for years. She unfolded it. It was a hand drawing. Precise dimension, the drawing of a man who knew how to translate a three-dimensional object onto a flat surface, the seat, the back, the legs, the joinery at each corner. Measurements noted in Leonard's compressed handwriting. Wood species, white oak. Finished Danish oil, 2 coats. At the top of the page, in the same hand, a single line. For Miriam, first season at Harper's Ferry. She stood at the workbench and held the drawing and looked at it for a long time. He had drawn this before he built it. He had known before the first piece of wood was cut exactly what the chair was going to be and who it was for. He had kept the drawing for 16 years in a locked box in the garage and had left the key with his attorney with instructions to give it to her when the time was right. She folded the drawing carefully. She walked to the porch. For now, she lifted the chair. She had been sitting in it for 16 years and had never looked at the underside, had never had a reason to look. It was a chair. You sat in it. It held. That had been the entirety of her relationship with its underside. She turned it over. The wood was smooth from years of use, darkened with age in the way of white oak that has been properly finished and maintained. And there, on the underside of the seat in the center, carved into the wood with the careful depth of someone who was not in a hurry, someone who was doing the thing correctly because it was worth doing correctly. L and M. 2 letters intertwined the serifs of each cut with the patience of a man who had spent 3 weeks on a porch chair and had been asked why, and had said if something is worth it, it's worth the time. She set the chair down. She sat in it. Nora arrived 30 minutes later. She came around the side of the house the way she had been coming to this house for years, without announcing herself familiar enough with the property to know that Miriam on the porch meant Miriam was where she needed to be, and that the right thing was to come and sit near her. She stopped when she saw Miriam's face. She said, "What did you find?" Miriam held out the drawing. Nora took it. She read the line at the top. She looked at the chair. She turned the drawing over in her hands and stopped. There was another line on the back of the page, smaller than the first, in the same hand at the bottom of the sheet where the drafting grid ended. She read it. Her voice was not entirely steady. She said, "Miriam, there's something else." She held out the drawing. Miriam took it and turned it over. Leonard's handwriting smaller at the bottom of the page. "If you're reading this, I'm already gone. Sit down in the chair. I built it to hold." Miriam read it once. She read it again. She set the drawing in her lap. She was already sitting in the chair. Nora sat down in the other chair, the one Miriam had bought the second summer because Leonard had built one, and she had wanted one too, and Leonard had said, "I'll build you one." And she had said, "You've done enough, I'll buy one." She had bought it. It was a good chair. It was not the same chair. Nora said, "He knew you'd find this." Miriam said he always knew. I just never asked him what he knew. They sat on the porch in the November afternoon, the West Virginia hills going their particular late autumn brown-gray, the apple tree bare the woodpile Leonard had stacked in August still holding its shape. The house behind them, the 3 acres in front of them, the chair under Miriam that Leonard had built in the first season because he had decided she needed a chair that was right and had taken 3 weeks to make it so. He had built it to hold. It was still holding. The ruling came on a Tuesday. Garrett called at 9 in the morning with the formal language of it. The will confirmed, valid the challenge, dismissed the estate to pass to Miriam Cross as Leonard Cross had intended. He read the relevant section of Judge Holmes' written decision, which was precise and thorough, and contained near the end a sentence that was not required by any legal standard, but that Judge Holmes had apparently decided to include anyway. The court notes that the handwritten addendum submitted by the decedent represents an unusually clear and unambiguous expression of testamentary intent, and that its language has been entered into the permanent record of this court. Miriam thanked him. She made a second cup of tea. She went to the porch. It was a November afternoon in West Virginia, the particular November of the eastern hills, when the color has mostly gone from the trees, but not entirely the last of it hanging in the oaks that were slower to turn than everything else. The light was the low, warm light of a late afternoon in autumn, the kind that found the remaining color and made it glow briefly before the dark came. She sat in Leonard's chair. She had been sitting in it for 16 years and had known it as a chair, a good one, the kind that held and did not shift, the kind that was exactly right in the way that things are exactly right when someone has taken the time to make them so. She had known this without thinking about it the way you know things that have become part of the ordinary texture of your life. She knew more about it now. She held her tea in both hands and looked at the hills. She did not think about the courtroom. She did not think about Diane, not with anger, not with the particular relief of a resolved conflict, not with anything that required energy. She thought about the first evening they had sat on this porch. Leonard had just finished the chair that afternoon, had brought it out and set it in its place and stepped back to look at it with the specific satisfaction of a man who has completed a thing he intended to complete. He had said, "Sit in it." She had sat. It had not moved. Not a shift, not a creak, nothing that suggested anything less than full structural integrity. He had smiled. She had not known then that it had taken him 3 weeks. She had not known about the evenings in the garage, the careful dimensioning, the drawing on the drafting paper, the decision to use white oak for its hardness and longevity rather than something easier to work with. She had not known about the 2 letters carved into the underside with a patience that communicated everything about who he was and how he loved. She had sat in the chair and it had held, and that had been enough. It was still enough. She thought about Diane, not with the bitterness of a woman who has been through a legal proceeding and come out the other side. She had moved through whatever bitterness there was in the months of preparation and the single day of testimony, and had come out somewhere quieter. What she felt when she thought about Diane was something that did not have a clean name, something in the vicinity of sorrow without quite being sorrow, the specific feeling of watching a person spend years looking at something and not seeing it. Diane had looked at her father for decades. She had not seen the chair. She had not understood that Leonard Cross expressed what he loved by building it, by measuring it twice, by choosing the harder wood, because the harder wood would last longer, by carving 2 letters into a surface that would not be seen by anyone unless someone turned the thing over. She had not understood that the notebook with its 9 entries and its flat observational notations was the same kind of expression, not anger, not accusation, just documentation. The record of a man who paid attention to things and wrote down what he saw. Diane had been looking for a different kind of father, a father who expressed things differently. That was not something Miriam could have given her, and it was not something Leonard could have been. She did not know whether Diane would ever understand what she had missed. She hoped in the quiet way she hoped for things that she would. The drawing was framed on the small table beside the chair. She had found a frame the previous weekend, simple wood, the right size, the kind that held something without drawing attention away from what it held. The drafting paper inside showed Leonard's precise dimensions and his notation at the top for Miriam. First season at Harper's Ferry. And at the bottom, in the smaller hand, "If you're reading this, I'm already gone. Sit down in the chair. I built it to hold." She had framed both sides, had asked the framer to mount it so that when you lifted the frame, you could see the back. The back was visible if you wanted to see it. The front was what you saw first. She sat in the chair with her tea and the November hills in front of her, and the framed drawing on the table beside her, an L and M carved into the wood beneath her, in a place she could not see but knew was there. Leonard had put it there in the first season. He had known something then that she had not known yet, or had hoped for something, had believed something enough to carve it into the underside of a chair. He was building for the first year of a life they might or might not build together. He had been that certain that early. She had not known. She knew now. She set down her tea. She said quietly to the November afternoon, to the hills, going their slow gold gray in the fading light, to the air, above the 3 acres Leonard had maintained, and the apple tree he had planted, and the woodpile he had stacked before he was too sick to stack it. He built it to hold. The chair did not move. The hills went on going dark in the way of November hills that have been doing this for a long time and will go on doing it long after the people sitting on porches watching them are gone. The chair held. It had always held. Leonard had made sure of that before anyone needed to know it would. The ruling came on a Tuesday.